Chicago judge has ruled Conrad Black must remain in the United States at least until she sees more details about his finances. Black very much wants to return to this country, even though he no longer has Canadian citizenship. Still, he has friends and supporters here. Given Black's criminal record, among other issues, can he come back to this country? Mario Bellissimo is an immigration lawyer in Toronto and joins us now. So Amy St. Eve, the judge presiding over today's hearing, said for her to even really consider Conrad Black's request to return to Canada, she would expect an extradition request. So obviously this goes to the government. Is that the usual drill in these instances, that there has to be an extradition request?
Well, an extradition request would be if they assume that there'll be further charges here in Canada for wrongdoing. Otherwise, what you're looking at is he has to make an application through ordinary course of an individual who's no longer a citizen, no longer a permanent resident. So by virtue likely of his wife, his home, he would make a temporary resident permit request, and it's a needs versus risk assessment.
So I just need to be clear here. So he really shouldn't be making the request to Amy St. Eve. Ultimately, he could, even now, put that request to the Canadian government. Is that what you're saying? Exactly.
A U.S. judge has no authority to allow entry to Canada. She may allow him to leave the jurisdiction based on his criminal bail, but to enter Canada, that would be a decision of the Citizenship and Immigration Branch. Okay, so let's assume the Immigration Department gets a request from Conrad Black. What are some of the reasons the Immigration Department might say, okay, you're in? Like, what would be persuasive? Again, it's a needs versus risk assessment. So what are the compelling need that he needs to return to Canada? So he has a wife, he has a property. Oftentimes it's employment, children. On the flip side, you're looking at the risk. What is the general deterrence factor? Do we want to allow an individual who's engaged in criminality in the United States to be allowed entry to Canada?
But if, in fact, throughout this process, it becomes clear that all the convictions against Conrad Black will be dropped, so he would be cleared, so therefore that risk argument would disappear, correct?
Yes, and what would happen is if all the charges and convictions did disappear, he would then be sponsored by his wife, who remains a Canadian citizen. Processing time is about a year.
And how compelling is the argument that his wife, Barbara Mill, is a Canadian citizen, that he has property in Toronto? Is that generally thought to be fairly persuasive with government officials?
No. These are exceptional remedies, so it would have to be something more compelling than that. An emergency, a need to get into the country, that his wife is not well. So it usually goes beyond the ordinary of, well, I have a wife and property in Canada, then we would open the doors to anyone who engages in criminality to return by virtue of marriage and property.
So I'm sure there are very clear rules, and the Immigration Department would consider all of this according to protocol and rules. But there are two things here: Conrad Black's profile and the fact that he renounced his Canadian citizenship. So would that work against him or not be relevant at all?
Well, I think it is an indication when he gave up his citizenship in 2001 for British peerage, that is an indication that he did make a choice not to be a citizen of Canada, so it would weigh in. And these decisions ultimately are highly discretionary. So although there are guidelines, officers are granted tremendous authority in deciding yes or no.
And routinely, how long does it take to make a decision? Let's say the request is in the works. You don't think the department would rule on it until the legal issues are resolved in the United States. But so how long would a request like this take to process?
It can go anywhere from months to over a year, because these requests have to be carefully weighed. Sometimes these requests are made within days in exceptional circumstances. Again, based on what I'm reading, I wouldn't see the exceptionality of that request at this point.
And would a request be considered now? Would it be processed now as a parallel process to what's going on as he continues to fight his convictions, or would Canadian officials actually wait until what's going on in the U.S. is determined one way or the other before they even start to consider the request?
I think he has one thing for certain: he has a very determined legal team, and he's determined as well.
That's true.
I think if I was part of his team, I would be looking at trying to seek a resumption of my citizenship, because that would eliminate any criminality. So there are ways you can seek to resume your citizenship. That would be one thing you could do contemporaneously. As for a temporary resident permit, you could not, because as it stands, he remains under order of a U.S. criminal court to not leave the jurisdiction.
Okay, very interesting. We'll definitely follow this. Mario Bellissimo, good to talk to you. Thanks for this.
Thank you very much.